from those who require them most, our poor and most vulnerable. Yet, has any of it been investigated and prosecuted? Why are there no prosecutions? Has the NPA been captured and rendered a toothless tiger against the machinations of state capture? Recently, we noted the public protector state that there are 118 outstanding cases of corruption languishing upon the desk of the NPA, mostly involving senior politicians and government officials. Advocate Batohi further stated that there were cases that should be revisited that were previously declined for prosecution by the NPA. Upon Advocate Batohi's recent address to the Portfolio Committee, she listed the following challenges being experienced at the NPA. These are lack of credibility, cases for prosecution which languish for a period of up to 10 years, and then they are simply withdrawn. Low staff morale, high vacancy rate, like 600 prosecutors recently resigning at the same time, limited professional development and training, divisions within the organization, severe budgetary limitations, and a weakened sense of values and identity. In addition, note must be taken that since 1994, the office of the NDPP has never had a single head who has completed his or her term in office. This speaks volumes regarding both the procedural appointment and removal of persons to this office by the head of state. Chairperson, it is additionally critical that an independent body be created to prevent, combat, investigate, and prosecute corruption in South Africa. The Scorpions were endowed with the capacity, but evidently flew too close to the proverbial sun of government corruption and were unceremoniously shut down through a simple majority vote in Parliament. They were then followed by the Hawks, which, despite Constitutional Court judgment confirming their lack of independence, continue operation to this day in effectively executing their mandate as their independence is clearly compromised. How should this be remedied? There is a solution which was proffered by Honorable Naren Singh of the IFP in his question to the Honorable President recently, and that is through the creation of an independent Chapter 9 Integrity Commission. The President, in his reply, referred to this proposal as refreshing. In conclusion, the government must act with all due haste and urgency against both public and private individuals found guilty of corruption. The IFP supports this budget in the interest of a robust, independent judiciary under the Constitution and the rule of law. Thank you.
Volgens is die achtbare lid Mulder.
Achtbare huisvoorsitter, minister Ramola, ander ministers teenwoordig, adjunct minister Jeffrey, lede amptenaars van hoofstuk 9 instellings en almal hier. Die departement van Justisie is veronderstel om die grondwet van Suid-Afrika en die oppergesag van die reg te handhaaf en te beskerm. Verder moet die departement toegang verseker tot 'n toeganklike, regverdige en koste-effektiewe administrasie van geregtigheid in die belang van 'n veiliger en volhoubare Suid-Afrika. Chairperson, Multiple commissions and parliamentary inquiries have been set up to probe allegations of state capture, poor governance and corruption. Corruption has a huge impact on the progressive realization of human rights, as resources for development are siphoned out. A National Director for Public Prosecutions is therefore of vital importance. Chairperson, South Africa has got a progressive constitution, but poor implementation of laws and policies, a disregard of constitutional values and inadequate cooperation by the executive and other institutions, with the result that constitutional guarantees are not translated into reality. The Human Rights Commission actually included this concern in its report to the committee. Chair, Honourable Minister Ramola, will the outcomes be different under your administration? Will the executive once again fail the Constitution? Will the executive once again fail South Africa? Your ministry and department is entrusted to uphold the Constitution. The Freedom Front Plus takes note of the fact that the Office of the Public Protector has been entrusted with more than 50,000 cases in 2016, of which 95% were bread and butter issues, and the 35,000 cases were finalized. There are still numerous serious cases outstanding where municipalities have clearly violated the South African Constitution, and the provincial and national executive failed to fulfill their oversight responsibility to respond or to act. Proper complaints have been lodged with the Public Protector, and in spite of several inquiries since 2016, no feedback or response have been received up to date. Die Hooggeregshof in Pretoria het in 2017 bevind dat die openbare beskermer advokaat Mqwebane se aanbeveling oor die mandaat van die Reservebank irrasioneel was en het dit tersyde gestel. Verder is daar ook nog bevindings oor die Estina melkplaas in Vrede en die nalate om op te tree by Petro SA waar in 1 jaar 14,5 miljard rand verloor is. Die kantoor van die openbare beskermer wek tans nie die vertroue van die publiek en die indruk word gewek dat die kantoor misbruik word in belang van interne faksiegevegte in die ANC. Dit is vir VF+ onaanvaarbaar dat belastinggeld ook op hierdie wyse verkoos word. Chair, law and order in South Africa is under threat. The Constitution is under threat, and where the government has failed with land reform, the process is now in progress to amend Section 25 of the Constitution to provide for appropriation without compensation. The Chairperson, this is a clear repetition of what happened in Zimbabwe. Nothing illegal will be allowed. Amend the Constitution, make it legal and pursue. Chair, this resulted in Zimbabwe's annual inflation rate to hit 175% in June 2019. Data on Monday, that's yesterday, showed that a return of hyperinflation is once again on the radar. Supplies of essentials such as bread, medicine and petrol are running short in the country, thus violating the human rights of the country's citizens. Chair, the shrinking South African economy and budgetary constraints mentioned in the committee report should be a warning that the Department of Justice and the Chapter 9 institutions supporting the constitutional democracy in South Africa will experience unbearable pressure to uphold its mandate in future. The Freedom Front Plus will continue to fight for freedom with justice. Thank you, Chair.
Thank you. We now invite the Honorable Deputy Minister of Justice and Correctional Services for Justice and Constitutional Development.
Thanks very much. It's always quite astounding to follow the Freedom Front Plus and hear them go on and on about how great the Constitution is when they opposed democracy in South Africa. But Honourable House Chairperson, Honourable Minister, Chair of the Portfolio Committee, Honourable Members, Director General and Heads of Entities, I see the Head of the Information Regulator, the Head of the Magistrates Commission, the Deputy Public Protector. Might have missed people, my apologies if I did. For a long time, the majority of South Africans were excluded from the justice system, unable to access justice services and unable to enforce their rights. Today, our justice system serves everyone in the country. Our small claims courts improve access to justice and make civil justice inexpensive, less formal, and accessible to those who cannot afford litigation in the ordinary courts. These courts are used to settle minor civil disputes and claims of up to 20,000 rand between parties without legal representation in an informal manner. When small claims courts were first introduced in 1985, in the time of Mr. Mulder there, they were established in Bloemfontein, Durban, Pietermaritzburg, Pretoria, Port Elizabeth, Rustenburg, and Springs. Even in 1994, at the dawn of our democracy, these courts were still mostly in white and urban areas. Today, we have 415 small claims courts with an extra 49 additional places of sitting across the country. In the last financial year, these courts disposed of 56,000 cases with claims to the value of 290 million rand. The Department of Justice is currently evaluating the legislative framework governing small claims courts. We want to ensure that these courts evolve in line with the Constitution, as these courts predate the Constitution, and that some of the procedures are further streamlined to make it more effective. Under the apartheid regime, many were charged with crimes, often political crimes, and left to face a repressive, unjust, and inhumane justice system on their own. Mr. Mulder, you wouldn't know anything about that. Many South Africans were denied access to courts or legal representation. For example, in 1992, a mere 2 years before the dawn of our democracy, a staggering 150,000 convicted persons were sentenced to imprisonment without any legal representation. In 1993, an estimated 60% of accused persons in regional courts were unrepresented, and in district courts the figure was about 89%. Today, Legal Aid South Africa continues to champion the rights of all persons to access justice through the provision of independent, accessible, and quality legal aid services in criminal and civil legal matters. In the last financial year, Legal Aid South Africa took on a total of 416,000 new matters, of which 362,000 were criminal matters and nearly 54,000 civil matters. The provision of legal advice in order to empower communities on their legal rights and responsibilities benefited 308,000 people via its national footprint of 68 local and 68 satellite offices, the legal aid advice line, and consultations with remand detainees. In total, 724,000 persons were assisted by the organization in the last financial year, of which 16,000 were children. Matters involving children continue to receive priority. In addition to providing legal representation to all children in conflict with the law, Legal Aid South Africa also does individual tracking of children who are incarcerated for periods of in excess of 1 month in correctional facilities. Legal Aid South Africa received its 17th consecutive unqualified audit opinion in the last financial year, confirming the organization's commitment to the responsible, accountable, and prudent spending of public resources. I'd like to take this opportunity to bid farewell and sincerely thank the former chairperson of Legal Aid South Africa, Judge President J.P. Mlambo, as well as the outgoing CEO, Ms. Vidu Vedulanka, who is here, for their immense contributions to the success of Legal Aid South Africa today. And I want to wish the new board under Judge Makume all the best and to continue the good work. We're continuing to look at ways of increasing access to justice. Community advice officers are often the very first port of call for persons or communities seeking legal advice. We're therefore pleased that we are finalizing the policy framework on community advice officers and to regulate community-based paralegals. This will be finalized upon the development of a funding model which is currently being prepared. Sustainable funding is vital, and we're looking at options around a mixed funding model to ensure the long-term sustainability of community advice officers. When it comes to the sheriff's profession, which is very often the first person somebody meets when dealing with the civil justice system, sheriffs play an extremely important role in the justice system as they serve court processes and execute warrants and orders of the courts. They're the arm of the civil courts. The continuous development of our court rules and processes will no doubt also impact on the traditional way of the work of the sheriff. In May this year, just before the end of the last term, I appointed 24 new sheriffs to fill vacant offices countrywide. And for the first time in our history, more women, that's 14, than men, 10 men, were appointed as sheriffs. Where in the past the sheriff's profession was overwhelmingly white and male, at the end of February 2019, that's before those appointments, of the 254 sheriffs operating nationally, 31% were female, so that's still some way to go. 36.2% were white and 63.8% were black. Chairperson, our department also continues to implement programs and activities aimed at enhancing the protection and the rights of lesbian, gay, bisexual, transgender, and intersex persons through the work of our National Task Team on LGBTI rights. For those who may not be familiar with the work of the National Task Team, the NTT is a very successful partnership between government and civil society and was named at by the United Nations Office of the High Commission on Human Rights as a best practice model, an international case study on government and civil society cooperation. South Africa also recently, last week, co-sponsored a United Nations Human Rights Council resolution to renew for a second 3-year term the mandate of the UN independent expert on protection against violence and discrimination based on sexual orientation and gender identity. Out of the 39 pending hate crime cases that were being tracked by the National Task Team's Rapid Response Team, 10 of these cases were recently finalized with convictions of life imprisonment for both rape and murder. In the current financial year, our department will convene a national summit on the protection of LGBTI rights in South Africa. To further ensure that the criminal justice system protects the rights of LGBTI persons who've been victims of violence, we will also roll out the guide for service providers in the criminal justice system on the protection of the rights of LGBTI persons, as well as assist the South African police with the rollout of the standard operating procedures for SAPS officials on LGBTI rights. We will also continue to protect the human rights of those living with HIV and AIDS. Last month, we, together with the South African National AIDS Council, launched the National Human Rights Plan in response to human rights-related barriers to HIV and TB services to, amongst others, reduce stigma and discrimination, to sensitize and train health workers and service providers, increase legal literacy campaigns, and strengthen access to legal support services for those living with HIV, AIDS, and TB. With regard to the National Sexual Offences Register, I think it's important to repeat what I'd said in the Portfolio Committee, that unfortunately the register as provided for in the Criminal Procedure Sexual Offences Act is not yet implementable, but I think there are real issues that we need to look at with regard to its implementation. Currently, only persons convicted of sexual offences against children and disabled persons are placed on the registry. Other sexual offences cases do not appear. An additional factor is that after several years, a person's name can be removed from the register. One of the issues we need to look at, is this register really necessary, especially since any employer, not only those who work with children and mentally disabled people, can go to the South African police to determine if a prospective employee has a criminal record. Currently, in terms of the Act, the information on the sexual offences register is confidential. But that is counterintuitive, considering that employees can go to SAPS for this information. So we need to relook at that issue, should it not be a public register. But these are some of the policy issues that must be considered before the registry can come into operations. Honourable members, we have no illusions about the levels of racism, prejudice and intolerance that they are increasing. One simply has to look at social media to see this. The Minister spoke about the adoption of the National Action Plan Against Racism, Racial Discrimination, Xenophobia and Related Intolerance. And this plan was adopted by Cabinet in February this year after extensive public consultation. It was lodged with the United Nations in New York on the 2nd of this month. It's a 5-year plan and will be reviewed after that 5-year period. And the main thing to happen now is the setting up of a governance structure, which is chaired by the Minister, involving government, civil society organizations, religious institutions, academia, sporting bodies, and the media. So that needs to happen. The Hate Crimes and Hate Speech Bill would also be revived. And then we also have equality courts. And we have designated, or the Act stipulates that all high courts are designated as equality courts, and all magistrates' courts have been designated as equality courts, and that is also then moving on to regional courts. Of the some 473 cases were registered in the equality courts countrywide in the last financial year. I think 2 of those relate to your member, Honourable Breitenbach, your member, Honourable Kola Barnard. Just for information. Of the complaints that were reported at equality courts nationally in the last financial year, over 50% of the reported complaints relate to unfair discrimination, followed by hate speech with 30%. I think Honourable Kola Barnard's cases were there. Given the relatively low number of cases registered in some provinces, we intend to embark on awareness campaigns to make everyone aware of the existence of equality courts and the types of matters that are dealt with by these courts. 2 provinces, that's Northwest and the Northern Cape, have been identified to have equality court awareness sessions, and will be partnering with Legal Aid South Africa, the Chapter 9 institutions, and other role players. Honourable members, when this House passed our Prevention and Combating in Trafficking of Persons Act, we said that the search for improved socio-economic circumstances and the demand for the services of victims of trafficking contribute to making persons vulnerable to becoming victims of trafficking. We passed the legislation because we're concerned by the increase of trafficking in persons, especially women and children. In April this year, the department launched the National Policy Framework on Trafficking in Persons in South Africa, which is a tool for the implementation, management, and monitoring of the Trafficking in Persons Act. Key activities include the establishment of an information system to track these cases inside and outside the country. Other activities include the launch of the training manual on the prevention and combating of trafficking persons and sector-specific training manuals for the Departments of Social Development, Health, Home Affairs, and Labour. One of our department's main priorities is to ensure that persons know what their human rights are and where to go when these rights are infringed. A democracy cannot flourish, let alone function, if we don't actively promote awareness of human rights. The main objective of the Socio-Economic Justice, or SEJA program, is to facilitate the realization of socio-economic rights for vulnerable and marginalized groups, and the strengthening of civil society organizations in the justice sector. Some members would know that the SEJA program, which is run in conjunction with the Foundation for Human Rights, and the chairperson of the foundation, Ms. Toko Mpumlwane, is here, is coming to an end this year. The program's been extremely successful when it comes to increasing awareness of constitutional rights and enhancing participatory democracy. We are pleased that the SEJA program has met or exceeded all its targets in the last financial year, the performance indicators, with 3.8 million people reached by multimedia campaigns to raise awareness and knowledge of the Constitution, nearly double the target set of 2 million. South Africa's commitment to multilateralism is realized by our dedicated and full participation in international, continental, and regional organizations. We continue to support the work that's being done by the United Nations, the African Union, and the Southern African Development Community. South Africa deposited its initial country report on the United Nations Committee on the International Covenant on Economic, Social, and Cultural Rights, and we were invited to the UN Committee to present this report in October last year. The feedback was positive, and the committee expressed their gratitude to South Africa for developing jurisprudence on the justiciability of economic, social, and cultural rights, and for promoting the human rights agenda within the United Nations system. Just before the elections, we presented our periodic report to the Committee Against Torture. The Fifth Parliament, shortly before its term ended, also ratified the optional protocol to the Convention Against Torture, and this optional protocol comes into effect this coming Saturday, which is a month after it was lodged with the United Nations. Chairperson, honourable members, just to respond to some of the issues, and I can't resist responding to Honourable Advocate Mlawutsi, who wasn't sure who the Minister of Justice was. It doesn't, unfortunately, surprise me, and it's unfortunately reflective generally of the EFF. We had a situation in the last Parliament in the Justice Committee where the EFF, or Advocate Mlawutsi, seconded the adoption of the Traditional Courts Bill. But when it came to the House, it was the EFF voted against it. The EFF voted against the Cybercrimes Bill on the basis of sections that had been taken out of the bill. Yeah, so that's the EFF for you. Chairperson, honourable members, in 2 days' time we celebrate the birth of President Nelson Mandela. Silo Hatting writes about Mandela Day and says there isn't enough for people to take action against poverty for an hour and 7 minutes on July the 18th each year, as this will not change systems and structures. Instead, we should use the campaign as a tool for social justice. We echo this call for social justice for all. Madiba said, remember to celebrate milestones as you prepare for the road ahead. When it comes to access to justice for all, there have been many milestones, and we are more than ready for the road ahead. Thank you.
Sithokoze Mhlonishwa, John Jeffrey. The next speaker is Honorable Swart from the ACDP.
House Chair, firstly, may we also congratulate you, Minister, and give you the assurance from our side that we will play a constructive opposition role and partner with you to find solutions to the many challenges facing our nation. Now, we as a committee are fully aware that the Department, the NPA, Legal Aid South Africa, the SIU, Human Rights Commission, and the Public Protector are suffering severe financial challenges. And this is impacting service delivery in the criminal and civil justice spheres. The constrained fiscal environment has resulted in a 2 billion baseline cut to the department's budget over the medium term, with 667 million in this year alone. Now, the question I posed in the committee is, yes, we call the members, we call the entities to come to the committee to hold them accountable, but how can we expect them to reach targets when they are not being properly funded? And we also need to ask the question, how did we land up in this constrained fiscal environment? And it is undoubtedly because of widespread corruption and state capture. And we know the new Zuma administration allowed itself to be captured in the interests of a family. But the corruption goes far deeper and far wider than that one incident. And this has resulted in billions of rands being siphoned off from the departments, from SOEs. The level of state capture is absolutely staggering. And in addition, as the Nugent Commission found, SARS was hollowed out, losing much of its expertise and resulting in tens of billions of rands, of tax rands not being collected. This is disgraceful. So obviously state capture and corruption was naturally part of the focus during the budget vote briefings. And we appreciate the forthright presentation by the NDP, Advocate Shamila Batoy, as well as the briefing by the head of the investigating directorate, Advocate Cronje. What is apparent is it's going to take some time for the institution for criminal action against those implicated in corruption, given the complexities of the case and forensic investigations required. However, we from the ACDP would urge that some action should at least be taken. People out there, the electorate, are waiting for action, and so we would urge as soon as possible for action to be taken. It is disgraceful that the Guptas were allowed to leave the country. In the 5th Parliament, we sat on the Eskom inquiry, and we knew what was going to happen. They were about to flee the country. They were about to take billions of rands, but nothing was done in this regard. We also welcome the exemplary work that is done by the NPA's Asset Forfeiture Unit and the Special Investigating Unit. But Minister, so much more could be done if these units were given additional funding. Clearly, the fact that almost 400 million is owed to the SIU is stymieing their work. This must be addressed at the highest level. And it is a matter of great concern that the Asset Forfeiture Unit that can collect billions has a 25% vacancy rate. So how do we resolve this funding issue? Do we stand every year, wring our hands and say, we're so sorry, we're so sorry, we're so sorry, go and do your work, we're so sorry. But we will hold you accountable for the targets. We will call you back. Firstly, let us accept political responsibility for state capture. Let us make sure it never happens again. And secondly, let us make use of the provisions of the Money Bills Amendment Procedure and Related Matters Act. This act was passed in 2009. Committee chairperson, we, as Parliament, appropriate funds. It is Parliament that can, within the fiscal environment and under certain conditions, recommend adjustments. Let us in this Parliament make use of those provisions. We can go to the Appropriations Committee and say, in this case, let us shift funds from that vote to another vote. Lastly, the ACDP would like to thank all the magistrates, prosecutors, legal aid provisioners, practitioners, court officials, Chapter 9 institutions who do their very best to uphold justice on a daily basis under very challenging financial and difficult conditions. I thank you.
Thank you. The next speaker is Honorable V. Zungul.
The Chairperson, Minister, we want to congratulate you for your appointment. I also want to take this opportunity to greet all of the honorable members today. We need to be honest with one another and ask, do we have the country which our forefathers fought for? The past 25 years was a transitional period after defeating the over 300 years of minority rule, hence with a constitution that is based on negotiation and compromise. The structure and functioning of our country is based on the CODESA negotiations and agreements. This is an unsustainable compromise, hence the inequality gap has widened and more people are becoming poorer. What are the facts in our country currently? We have a Eurocentric constitution that does not speak to the spirituality, morality, and culture of Africans. A child as young as 12 can abort without the consultation of their parents, whereas a person under the age of 18 is regarded as a child and needs to have a guardian. The Constitution recognizes the institution and the status and the role of traditional leadership according to customary law. Yet we have the Abatembu King, Ikumkanu Dalindyebo, sitting behind bars. African law has been relegated to be second fiddle, and we are governed by the Roman Dutch law, whereas we are Africans with African norms and values. In other words, we are made to be foreigners in our own country. In the same right, we have the certain kingdoms that were destroyed in the colonial period still not reinstated. We still have apartheid laws in practice and people are still charged based on those laws. For example, the Rioters Assemblies Act. The very same constitution is allowed for foreign companies to have mining rights in for our God-given minerals. To show this constitution was not the will of the people even 23 years ago, there was a public outcry when the death penalty was abolished. Now, there's this narrative that we've got the best constitution in the world. Now, the question is, who is saying that? Is it the people of Siabuswa, Leboahomo, or Kuruman, or is it the investors, or is it the people outside of the country? And if it's the best constitution in the world, why aren't we seeing other countries copying our constitution because ours is the best? Rather than dealing only with Section 25, Parliament must be proactive and look at the entire constitution to ask if it is the will of the people of South Africa. The people do not serve the constitution serves the people. We need a constitution that is an expression of the will of the people. We need a people-centered and a people-driven constitution that seeks to defend and advance the interests of the people of South Africa. As the ATM, we support the budget. Thank you.
Order. Order, honorable members. The next speaker on the list is Honorable Ash Mohammed.
Thank you, Chairperson, Honorable House Chairperson, Honorable Minister Ronald Lamula, Deputy Ministers Jeffrey and Holomisa, members of the Justice Portfolio Committee, honorable members, leaders of the judiciary present, leaders of Chapter 9 institutions present, comrades and friends, invited guests, fellow South Africans. I rise on behalf of South Africa's oldest liberation movement, the African National Congress, in support of this Budget Vote 21 as tabled by our Minister here today. Chairperson, we wish to also congratulate our new Minister and Deputy Ministers on their appointment and pledge our commitment to work with them. I would like to dedicate this, my maiden speech in this august house, to someone who influenced my life in a monumental way, the late Dalla Omar, who was a member of this house and also the first Minister of Justice in democratic South Africa. He was a remarkable human being who mentored many and played a major role in shaping the lives of the youth of my generation. He taught us as young people not to mistake the law for justice, that justice is an ideal while the law is a tool, and that access to justice must reach the voiceless and the vulnerable. We are reminded of these values, Chairperson, and the objectives which he espoused. We wish to thank also the people of South Africa for entrusting the African National Congress to improve the operations of the justice system and to ensure that there is access to justice for all. The National Development Plan, Chairperson, Vision 2030, oblige us to build a country where all people are and feel safe. Central to this becoming a reality is the work of the National Prosecuting Authority. Adequate funding, as we heard, for the NPA has been a concern. The projected shortfall on compensation for employees compelled the NPA to reduce its staff establishment and to remain within its budget. It also had to adjust certain medium-term targets relating to the convictions in courts in line with the resource constraints that the NPA is facing. Minister, we're glad that the Treasury will be engaged on this soonest. We are also confident that the new investigating directorate of the NPA will serve as a key pillar of our President's anti-corruption objectives with the aim of ensuring successful prosecutions and asset recovery. Parallel to the work of the Investigative Directorate is the work of the Special Investigative Unit. We also welcome, as the ANC, the establishment of the Special Tribunal, which is tasked with adjudicating civil processes aimed at recovering monies siphoned off through corruption and other forms of illicit monies. Honorable members, the 54th National Conference of the ANC reaffirmed that government must transform the legal profession and strengthen the briefing of black lawyers, particularly black female lawyers, so as to equip them to defend the state and thus creating a pool for potential judges. We call on the department to swiftly transform the current briefing patterns. Our President, in his State of the Nation address, said that the eradication of gender-based violence, Chairperson, requires top priority. This includes ensuring the improved functioning of sexual offences courts, and we note that, Minister, that 16 sexual offences courts are to be adapted in line with the sexual offences courts model, which we welcome. It is, however, concerning that funding constraints have led to a moratorium on the appointment of further intermediaries, which we hope the department will mitigate soonest. Chairperson, we live in a world where levels of poverty, inequality, especially among women and single parents, are increasing daily. That is why accessing child maintenance services at courts are vital. We commend the department on the implementation of Moja Pay and EFT payments made to maintenance beneficiaries directly, which has proven to be successful. There are, however, too many maintenance defaulters, and some NGOs have expressed concern in this regard due to the insufficient dedicated staff at courts. In the light of moving towards the fourth industrial revolution, Minister, which you have propagated, we must explore the possibility of how certain categories of maintenance applications can be made online. Honorable Chairperson, it is important for the Human Rights Commission to focus on the realization of socio-economic rights, as this has a direct impact on the poor and the vulnerable. We therefore commend the investigation undertaken by the Commission currently into whether the City of Cape Town's bylaws are infringing the human rights of homeless people. We also salute the Human Rights Commission for working together with the Department of Basic Education in the rewriting process of the first orientation textbooks, or life orientation textbooks, for grades 4 and 12, thus infusing human rights issues into the school curriculum, and for agreeing to lead the National School Moot Court competition, working with the Department of Justice and the Department of Basic Education. Chairperson, young people are most affected by poverty, inequality, and unemployment, and sometimes become involved in petty crimes. Years later, they may be unable to find a job because they have a criminal record for this petty crime and would have paid an admission of guilt fine. This process, so the process of expungement of criminal records becomes very important. there are stringent and strict criteria, and one can only apply after a period of 10 years has lapsed after the date of the conviction of that offense. This is something we would like the department to brief us on, since it may enable young people to find employment and fully participate in order to fully participate in the economy. Chair, as we remember Dalla Umar, in my earlier reference to him and his values, we can be assured that we are indeed achieving a great deal and that the struggle for access to justice for our people within the culture of human rights continues. Lastly, I want to also, on behalf of the ANC, thank the staff, the research unit that assisted the committee during this budget, preparing for this budget vote under tremendous time constraints for a job well done. Thank you very much, Chairperson.
Thank you. The next speaker on the list is Honorable Nyozo.
Chairperson, the PAC remain convinced that when we discuss the question of justice and constitutional development in the country, we must begin with the type of judicial system that we have allowed ourselves to be subjected to. We have allowed ourselves to be dominated by the same system that informed our oppression, without any attempt whatsoever to introduce an African-centered jurisprudence. The same laws that were used to justify land theft are still used to protect the beneficiaries of land theft. The very laws that were used to arrest, sentence, and incarcerate our aplacadas are still used to keep them in prisons today. Minister, the fight against apartheid was never a round-table discussion, but rather a matter of life and death. And our aplacadas, who were at the forefront, had to engage the system the only way that would be forced them to surrender, and that was through the barrel of a gun. The PAC called for the release of aplacadas who are still in jail. Chairperson, our justice system turns a blind eye when injustice is done by the government, and when the people respond to the injustice, the justice opened its eyes and go harsh on the people. Hence, we have students in prisons. The PAC remained disturbed that the government refused to release records of President Robert Sobukwe's voice when he was addressing the court. Our system keeps records of the court proceedings, and such records should be made freely available. We call for the release of these records without any further delay. In conclusion, the PAC proposes that we do away with the usage of Roman Dutch laws and invest in the African-centered legal system. The PAC supports the budget.
Thank you. The next speaker on the list is Honorable W. Hon.
Chairperson, justice and constitutional development has a major role to play to restore the confidence of South Africans and the world in our country and its constitutional institutions. Governance, policies, strategies, programs, and budgets cannot be mere tick-box exercises if we are to restore our image as a constitutional democracy which is on the path to prosperity. In addition to the vital need to deal speedily and effectively with corruption and state capture, our ability to deliver justice to the thousands of victims whose personal safety are breached and broken down every day in our streets and on our farms is of equal importance if we are to restore confidence in the NPA and the criminal justice system, and if we are to fulfill the dreams President Ramaphosa has of reducing crime by 50%. For let there be no doubt, the current composition, skill set, and budget of the NPA is in no way aligned to this target. This is not a political statement. It's a statement of fact based on what the NDPP and the Department of Justice informed the Portfolio Committee during our budget briefings. Minister, the buzz term being thrown around by you is the request to the NDPP to develop a plan to make the NPA effective. There may be a need for such a plan, but allow me to make it very simple. Your short-term priority must be to ensure the proper funding and upskilling of the prosecution services of the NPA. We welcome the appointment of 19 prosecutors at one-man stations, but in the bigger scheme of things, this can be only symbolic. We need more prosecutors at more stations. In respect of the effectiveness of the NPA, we welcome the insight of the new national director and her willingness to admit that conviction rates as a percentage cannot be the only or even the most reliable way to measure success at the NPA. Let me state only one of the real numbers that paints the sorry state of the NPA decline over the last years. Despite fewer criminal cases being enrolled, the backlog roll, that's cases being on the roll for 12 months and more, is estimated to grow from about 28,000 3 years ago to 35,000 towards the end of this financial year. And Chair, while this issue must not be politicized, it must be said that the snide and personal remarks by the Honourable Jeffrey is a testimony of the unconcerned manner in which he has dealt with this matter over the years. Forever obfuscating about the failures of the system, and one must wonder, is it possibly because he wants to protect the cronies from the Zuma faction when the law comes from there, for them? Honourable Lamula, in the short and medium term, your legislative agenda will also either work towards restoring confidence that this government has re-embraced constitutionalism, or that it is continuing on the path of what can at best be described as reimagining South Africa in line with the rule of man rather than the rule of law. In this regard, you should be warned not to place too much trust in your deputy minister. While he was part of the Zuma administration, he brought us some very bad bills, bills that not only undermined the rule of law and our international obligations, but which he also was well aware could never pass constitutional muster. A cybersecurity bill which in typical Zuma-era thinking could not imagine a South Africa where the state security agency is not at the center of every state operation. A traditional courts bill which panders to the worst unconstitutional instincts of some traditional leaders and the half-hearted Democrats in the ANC. Rebuffing the constitutional demand that customary law and practices are to be recognized and developed only in a manner consistent with the Bill of Rights. A hate speech and hate crimes bill which sought to criminalize offense and to clamp down on free speech instead of establishing a true culture of human rights earmarked by tolerance. Not one, but two attempts to facilitate our withdrawal from the International Criminal Court on the back of the friendship of the government with the Omar al-Bashir, a despicable dictator wanted for crimes against humanity, war crimes, and genocide. Minister, whatever you do, never rely too much on the advice and opinion of your deputy when it comes to your legislative agenda. His ability to identify and prevent legislation that's averse to our Constitution is severely impaired by his service to the Zuma administration. Chairperson, we note the announcement today by the Minister that he will ask Parliament to proceed with the finalisation of the Traditional Courts Bill and the Prevention and Combating of Hate Crimes and Speech Bill. We reiterate our serious reservations about these bills and urge the Minister to first do a constitutional and specifically a Bill of Rights audit on these bills before putting his stamp of approval on them. We also place on record that there is a dire need for cybersecurity legislation. But please, Minister, only after it has been reworked to address the over-involvement of SSA in the administration of the law. Allow me to add that we hope that your silence, Minister, on the International Crimes Bill means that the ill-advised decision to withdraw from the International Crimes Court has been abandoned. In respect of other matters in need of the Minister's attention, Chair, we welcome the announcement of imminent steps to address the deficiencies at the state legal services. Other pressing issues must include the embarrassment that is the process of bringing into operation the information regulator. And Minister, our best advice to you in this regard is also to take control personally of this, because your deputy has also failed in this regard. Chair, the snail's pace at which the integrated criminal justice system is being developed, it having been announced 12 years ago already, and having gulped up hundreds of millions of rands of taxpayers' money, is also in need of special attention. Minister, we also urge you to stay true to your word to address the institutional independence of the NPA and the NDPP. This, Minister, is the mission you chose to accept. We wish you success. I thank you.
The next speaker on the list is Honorable James Fuking.
Thank you, Chairperson. Thank you, Minister and Deputy Ministers, honorable members, ladies and gentlemen. From the onset, I wish to declare the African National Congress support for the budget, Vote 21, as tabled by Minister Lamola here today. Honorable Chairperson, the main objective of the National Democratic Revolution is to attain a non-racial, non-sexist, united, and prosperous society. For the purpose of this debate, I will place emphasis on the non-sexism, which is foundational value of our Constitution. The Constitution guidelines provide for equality between men and women. This value did not fall from the sky, nor was it an accident of history. It is a direct response and challenge of the patriarchal society we find ourselves in. Throughout history, women have been marginalized, regarded as the weaker sex and incapable of fulfilling their duties, which were traditionally considered as being for men. History teaches us that women in most parts of the world, including South Africa, were considered perpetual minors without rights to property, to inherit, to vote, to hold legal power, to hold certain occupation. Married women were legally dead in the eyes of the law. History teaches us that women were relegated to the lower ranks of society. Throughout all of this, history also teaches us that the bodies of women have been considered and treated as objects. Honorable Chairperson, there have been a war against women. The war is still on. The progressive women's movement against sexism, femicide, and gender-based violence have not stopped. The killing of women and members of the LGBTQI+, women are in a state of constant fear of violence and abuse. The gruesome killing of women and girls, either by intimate partners, relatives, or strangers, continue to traumatize our communities. The trend of discarding the victim bodies without any thought, bludgeoned, dismembered, or burned, is shockingly inhumane. The root of this all is patriarchy. All these atrocities are manifestation of patriarchy and needs to be unrooted and eradicated. It is an injustice to the lives of women. It must be noted, Chairperson, that our revolution as the African National Congress was never about fighting men. Our revolution was about fighting patriarchal system. Last year, President Cyril Ramaphosa called a presidential summit on gender-based violence and femicide, where he declared gender-based violence and femicide as a national crisis. The acknowledgement requires that action be taken if we are to realize outcome 3 of the National Development Plan, which entails that in 2030, people living in South Africa feel safe at home, at school, at work, and enjoy a community life free of fear, and women walk freely in the streets, and children play safely outside. Honorable Chairperson, rape targeting women and girls is a serious problem in South Africa. The 2016-2017 Victims of Crime Stats release reported that 250 out of 100,000 women were victims of sexual offenses, compared to 120 out of every 100,000 men. The stats are deeply concerning. The African National Congress called for harsher sentences for those who committed gender-based violence. A woman's body is not a crime scene. The body of a child is not a crime scene. The body of a member of the LGBTQI+ community is not a crime scene. Deputy Minister, we agree with you that sexual offense register need to be looked at, and public participation should be key in this regard. Honorable Chairperson, Notwithstanding these challenges, the ANC has not been silent. The Department of Justice has progressively rolled out sexual offences courts because on this nature of sexual violences, many survivors of sexual abuse choose not to report this crime, mainly because of shame or fear or for not being believed. The sexual offences court are therefore established to give them an experience defined by solace, care, compassion, and justice so as to encourage reporting and healing. Sexual offences courts are intended to reduce the turnaround time in the finalization of these cases, eliminate secondary victimization, and improve prosecution and adjudication of the cases. The sexual offences courts offer a sequential and coordinated flow of victim centers, support services, which include information, private waiting room, court preparation, pre-trial emotional containment, private testifying, intermediary and post-trial emotional containment, to name a few. With this in place, our young women lawyers should find expression in this. The National Prosecution Authority, in collaboration with the Department of Health, has established the Tutuzela care centers throughout the country, and we support them. As reported by the National Prosecution Authority, the life sentence imposed at the sexual offense courts on cases received from the Tutuzela care centers increased by 36.5% in 2017-2018 financial year. From 255 life sentences in 2016-2017 to 348 in 2017-2018 financial year. This indicates that the courts have started to turn the tides of sexual offenses in our country. As at the 31st March, the South African Police Services established 1,049 victim-friendly rooms at certain police stations. This is an increase from the 1,027 that were there in 2016-2017. They provide a friendly environment that assures confidentiality, respect, and dignity. In Gauteng, there are 137 VFRs and are operational. We hope this will assist in prosecution. The Department of Social Development has also established 6 Kuseleka one-stop centers, and we hope that they will also be able to acknowledge the work that has been done by Ikaele Temba, one-stop station established in Gauteng. Section 29 of the Criminal Law, Sexual Offences and Related Matters, Amended Act requires the Minister of Health to designate by government notice any public health established to the purpose of, inter alia, 1, it will be providing the post-exposure prophylaxis, and then 2, it will be carrying out the compulsory HIV testing, and it will be actually going on pregnancy testing and all that medical examination, collecting of forensic evidence, completion of the medical report, and provision of a contraceptive treatment. That is in the nutshell. Honorable members, as the ANC, we have made great strides in ensuring that justice is made accessible through where the physical location of these structures are placed. We have progressively ensured that the right of legal representation is enforced through the rollout of legal aid services. We acknowledge the good work that they have done. We are concerned with its limited funding. However, we appreciate the good work that they continue working with the South African Human Rights Commission, the NPA, Legal Aid South Africa, and the department as a whole, especially in this fight of ours against the scourge. We call for a social compact to fight patriarchy, gender-based violence, and femicide. Women's lives matter. Even as we differ politically, we are in agreement that human rights must be protected and the lives of women, children, persons living with disability, and the LGBTQI+ community must be protected. Honorable Chairperson, I end as I do with a quotation of the formidable man who has often been described as a feminist at heart. the first democratically elected president of South Africa, Madiba, President Mandela, who said, I quote, as a tribute to the legion of women who navigated the path of fighting for justice, of fighting for justice, because before us, we ought to imprint in the supreme law of the land firm principles upholding the rights of women, I close quote. I would like to actually go back to Honorable Breitenbach. On the public protector issue, the ANC is not going to do what you want, but the parliament will do the right thing as per parliament rules and the Constitution of South Africa. For Honorable Mulaudzi, you have nothing to offer, and we cannot even listen to you. Honorable Deputy Minister, thank you for appointing women, especially 14 as sheriffs. We really owe a thank you to that. And Honorable Swart, thank you very much. Oh, your goeie moed, van slechte moed kom vanself. Honorable Swart, want to thank you for always being positive in this committee. As for Honorable Horn, you did nothing and you say nothing, but you just wish to be a deputy minister. Thank you very much.
Thank you, honorable member. I will now invite the honorable minister to close the session.
Thank you very much for this opportunity to respond, but also to thank all the political parties for their constructive inputs, largely constructive, and I will not be able to respond to each one of them because of the constraints of time, but some of the responses will come through action in our day-to-day work, on the execution of the task, on our respect of the Constitution. I think most of the parties, unlike Honorable Advocate Mlaudzi, have acknowledged the new dawn and have brought their new speeches for the 6th administration. I think what did a disservice to Honorable Mlaudzi was to mistakenly bring the speech which he used for the 5th administration. On corruption, the ANC government is unflinching on its commitment to deal with corruption. And I'm happy that the president has implemented the recommendations of all the commissions of inquiries that have set thus far, the NPA, the South African Revenue Service, and there is nothing that is going to stop us to implement the recommendations of any commissions that are currently sitting. But the chairperson of the Commission on State Capture, the Deputy Chief Justice Zondo, has also said that there is nothing that stops any law enforcement agencies, if on the facts before them and the facts before the Commission, for them to act on anyone or on any matter. We want to see the commissions fulfill their lives, having lives of their own. The chairperson has said there is nothing that stops the NPA, the SIU, or anyone, or the police, hawks, to do their job based on the evidence before the commission. We are also, the NPA is currently working with the SIU to deal with all the cases that the SIU has referred to the NPA to decide whether to prosecute and not to prosecute. And we have said ourselves, including the Constitution of the Republic and the NPA Act, they must be able to do their job without fear, favor, or prejudice to anyone. With regard to marijuana, we are at an advanced stage of developing a bill. And I think this committee will be soon seized with that bill as it's gonna go to cabinet. With regard to brief in terms of the State Attorney's Office, the department regularly updates on a quarterly basis the briefs that we are doing as a department. And we have recorded in the speech almost 84% briefing patterns, high rate to black females and males, with a more obscured towards black females. I think the challenge which we have, and we have said even in the speech, is that the private sector, the private sector, listed companies, unlisted companies must also come to the party It can't only be the responsibility of the state to brief black attorneys and black advocates. We have also going to engage with the Department of Public Enterprise in this regard so that our own state-owned entities are also seized with the transformation of the judiciary, the local government area, and all organs of the state. But this does not only end with the state. The private sector must also come to the party. This country, social cohesion is not only the responsibility of government, it's a responsibility of all social partners in our country. With regard to the security that has been raised, we are also working in the department, looking at also ensuring that securities in our courts, the standards are in line with the norms that are expected in any society, so that witnesses or anyone who working in our courts are able to do their job without fear or favor. Our commitment to a constitutional democracy can never be challenged or be questioned in the past 25 years. We have respected court decisions. We have done everything in line with the Constitution. And I think I speak today, the former President of the Republic is at the Zondo Commission of Inquiry. This is a true reflection that our democracy, we're not trying to hide anything. We allow institutions to do their job and process whatever that comes through proper procedures and processes in our constitutional democracy. With regard to political prisoners, I must be able to say that some of the political prisoners being spoken about, you are aware that they were refused amnesty. And it made also almost impossible because of the nature of the crimes that they have committed. But currently, the president is looking at the presidential pardon through the process that was started by the former president of the republic, former President Thabo Mbeki,
Honorable
and
Minister,
is going to soon.
your time is up.
Thank you. He will soon release the report. Thank you very much.
That concludes our debate. The mini plenary is adjourned. Thank you.